Good morning, everybody. My name is Michael Hanrahan, and I am a clinical facilitator with the Provincial Mental Health Act and Community Treatment Order team, part of the Provincial Addiction and Mental Health portfolio. And I will be going through the presentation with you this morning. I'm also joined by Shannon Wilkie, who won't be sharing video, but will be you'll be hearing her voice probably a little bit later. The way that this webinar is set up, everyone will notice on the bottom or maybe the top of your screen that there's a Q&A icon. We're going to go through the presentation. If you have any questions, you can certainly type them into the Q&A text box. That will allow us to record all the questions that are asked. Shannon will reply to some of the questions live as we go through. If I notice some of the questions and it lines up exactly where we are, I may answer a few live as well. But the presentation is designed so that we should have some time at the end that we'll be able to get through any of the questions that are asked. Any questions that we don't address in the presentation today or we don't have an answer for, we can follow up individually. This session is being recorded as well. Everyone's mic has been muted. Your video cameras don't work, so don't worry about being caught unaware. So with that, I think we'll go ahead and get started. So I'll stop sharing my video here. So today's presentation is focused on the recent amendments to the Mental Health Act. So Bill 17, the Mental Health Amendment Act, was tabled in the legislature in the spring of 2020, and it was most of it was brought into proclamation on September the 30th of 2020. So that's when the amendments to the Mental Health Act would have taken effect. So today we're going to be doing just an overview of what these changes were. We're going to be touching on the surface of the changes. There are a number of implications to practice in working with the Mental Health Act that are still being figured out. So unfortunately, I'm sure there are going to be some questions that we don't have full answers to today. But as we're going through, keep in mind that we will be offering more detailed education sessions coming up a little bit later in the fall, and those will probably continue over into the new year as well. That will look at the Mental Health Act as a whole, not just the more recent changes. So before we get into the details of these changes, it's important to have a little bit of a context. So Bill 17 was proposed more or less as a direct response to a court case. So in 2014, there was an individual who was admitted as a formal patient at an Alberta Health Services facility and remained there for approximately 9 months before eventually the courts decided to cancel the certifications. There had been a review panel that upheld the certifications, but the person challenged those through the courts and was successful in that challenge. Subsequent to that, there was a separate application to the Alberta courts to look at whether or not the Alberta Mental Health Act, as it stood at that time, violated the Canadian Charter of Rights and Freedoms. That court case took some time, so all this began in 2014. In the summer of 2019, the court made a decision and agreed with certain aspects of the person's application. So there were several sections of the Mental Health Act that were struck down. The effect of that decision was suspended for a year, which gave the government a year to make the changes in order to have the Mental Health Act be compliant with the Charter of Rights and Freedoms. So originally those changes were supposed to be completed by July of 2020. However, because of the COVID-19 pandemic, there was an extension that was granted, pushing it back to September the 30th. As we're going to discuss, there was also a separate application that was made, and a few of the changes were not enacted, did not come into force on September the 30th. So when we're looking at these changes, there are some new authorities, there are some new terms that have been introduced. Several sections of the Mental Health Act have been amended. we will look at those in a little bit of a systematic order. The first thing that I want to note, one of the changes that was discussed prior to September the 30th and received a lot of attention was the change to the definition of a mental disorder. This new definition, it will come into effect, but there was an application to have this delayed. So the new definition is not going to take effect until March 31st, 2021. So as we go through, we're going to discuss changes to the criteria, changes to the forms. For right now, the definition of the mental disorder has not changed. So it remains that mental disorder means a substantial disorder of thought, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life. Once this new definition comes into effect in March 2021, the mental disorder definition will not include a disorder in which the resulting impairment is persistent and is caused solely by acquired or congenital irreversible brain injury. There's some clarifying language that has been put into the Mental Health Act regulation, which is now, you can see what those changes are. But it will not come into effect, like I said, until March 31st, 2021. Essentially, what's going to be excluded with this definition are situations where the reason the person is presenting for admission as a formal patient is a condition that A, is not going to change, it's been persistent, and it's caused solely by this acquired or congenital irreversible brain injury. So that doesn't mean that people with brain injuries cannot be admitted as a formal patient, but it will mean that they have to have a disorder above and beyond this acquired or congenital irreversible brain injury. The clarifying language in the regulation will discuss about some exceptions for neurodegenerative disorders, and there will be further education and resources made available prior to March 31st that discuss explicitly the impact of this change coming in March. One of the things that has changed effective September 30th, 2020 is the criteria for admission or renewal as a formal patient. So on the screen, you'll see that a couple phrases have been highlighted, bolded. And so suffering from a mental disorder is still the first criteria that we would need to meet to have somebody admitted or renewed as a formal patient. The disorder will change March 31st, as I mentioned, but currently we're working with the same disorder we have been for many years. The second criteria is where we start to see the first change. So individuals must now have demonstrated potential to benefit from treatment for the mental disorder. So in supporting the facts on a Form 1 or Form 2, the individual who's issuing that form will have to put in some statement indicating their opinion that the person can benefit from treatment. When we look at the third criteria related to risk of harm to self and others, we have a couple of new phrases that are introduced or new concepts. So the first is that the likelihood of harm or negative effects must be something that's going to happen within a reasonable time. And reasonable, unfortunately, is not a term that is defined in the Mental Health Act, and it has not been defined in the past. So when we're looking at what is reasonable, normally we would be looking towards case law or decisions from review panels to kind of guide us in what's considered reasonable or not. Because these are new amendments, we don't have that background to draw upon. So we have looked towards how the term reasonable has been used in other legislation and other situations. And we're left kind of with this vague idea that reasonable is what a reasonable person would find to be reasonable if they were presented with the same information, which is a little bit circular and doesn't get us to, 1 day, 2 days, 3 weeks, or any kind of concrete conclusion. So for now, what we're advising is that your determination of what's reasonable should be really well documented and articulated, so that as we go through these changes, we see the decisions coming from the review panels. We may see decisions coming from case law in the future. that we can kind of start to get a better sense of what is reasonable as a whole. But for now, it's up to the individual health professional to make their determination based on the facts available to them and to make sure that their rationale is documented. As we get a more concrete sense of what reasonable means in the application of the Mental Health Act and reasonable time, helpful resources will be made available, but there's just not a whole lot that we can provide right now. The second part of criteria 3 that has changed is that the harm or negative effects that we're discussing have to be a result of or related to the mental disorder. And so some connection that the potential harm that may happen is directly related to the mental disorder needs to be documented. The fourth criteria for admission or renewal is not changed, and that's the individual is not suitable for admission in any way other than being a formal patient. So obviously with the change in criteria, there have been some changes to admission and renewal forms, but there's actually been a lot of revisions to all of the forms, some more substantial than others. So most of the Mental Health Act forms were updated on September the 30th, 2020. So when the clock went from the 29th to the 30th, there was some magic that happened. Some people worked really hard, and the forms were made available on the Alberta Health Services external website where they've always been located. Forms are now in a browser-based format and are best viewed using a modern internet browser. So update those if you're like me and don't do that very often. The forms can be completed on the computer. You can print them and sign them, or you can print a blank form and complete it by hand and sign the form. It's recommended that you always use the print function that's available at the bottom of all the forms. That maintains the best formatting. If you use your browser kind of file print option, a lot of people are used to that. Unfortunately, that will change some of the formatting, and in some cases, it means you're printing out many more pages than you need. Sometimes the text gets squished in a way that makes it a little bit less convenient to read. So always use that print button that is included in all the online forms. We are recommending that all old forms are destroyed, unused copies. So if there's a stockpile that's been laying around, especially for the less frequently used forms, try to make sure that those get destroyed, and always be using a form that you're printing directly from the website. That's the best way to make sure that you've got the most up-to-date version. Since the forms have changed on September 30th, a number of small errors or changes in format have happened. So the best way to make sure you're using the most current version is to be filling it out, printing it directly from the website as you need it. Any instances where older versions of forms were used after September the 29th, it's a recommendation that they should be replaced with new versions. And in some cases, that will mean that a whole new assessment or a whole new process would have to be started. We're far enough away now, hopefully this hasn't happened. For situations where, for example, a person was admitted as a formal patient prior to September the 29th, and now they're being renewed, I guess they would have been renewed at least a few weeks ago now. In those cases, that's fine because the entire process started and ended before the 30th. But the renewal for that patient would have to be on the new renewal forms. So this table is just to highlight some of the form changes that are significant to admitting or renewing a formal patient. So there is a new form, Form 2.1, which is the cancellation of admission certificate or renewal certificate. And this form didn't exist prior to September the 30th. It's to be used only in situations when a formal patient, so somebody who has 2 admission certificates or 2 renewal certificates, no longer meets one of the 4 criteria. And so this is a formal mechanism now to cancel those admission or renewal certificates. This has always happened in situations where a CTO has been issued for somebody who is a formal patient. The Form 19 being issued has always canceled admission or renewal certificates. But for those individuals who are no longer meeting the criteria and are either being staying in hospital as a voluntary patient or being discharged completely, then this Form 2.1 would have to be completed. And we'll discuss some other specifics about the form a little bit later in the presentation. Form 17.1 is also a new form. This form is a form that's completed by the mental health review panels, specific to issuing a community treatment order when that has been requested by a formal patient. So that's one of the other amendments that we'll talk about. So this 17.1, this new form, is related to some new authorities that the review panel has. Form 17, still named Form 17, but there have been some changes to the decisions that the review panel can make, again, related to some new authorities that they have. And we'll talk about those in more detail later. A couple of forms have had their number changed. So the community treatment order written statement, which had previously been known as Form 26, it has been renumbered to Form 25. The community treatment order non-compliance report, previously known as Form 27, has been renumbered to Form 26. Both of these changes are a direct result to the removal of the community treatment order designation of physician form, which was previously Form 25. That form no longer exists, and that's because the section of the Mental Health Act allowing for the designation of a physician has been removed, and we'll talk about that in a bit more detail here. And lastly, the application for review panel 12, it's still Form 12, but again, because the review panel has some new options, there have been a couple of additions to the application itself. So if you look at it, you'll just notice that there are a couple other reasons that somebody could request a review panel. One of the other big changes that has gotten a lot of attention relates to the introduction of the term qualified health professional. And there is a lengthy definition of qualified health professional that you can read in the Mental Health Act, which has, after us waiting since September 30th, is finally available in the Queen's printer, so you can get your own copy and print it out and have it as a reference. The qualified health professional, as of September 30th, refers to a psychiatrist, a physician, or a nurse practitioner. So throughout the Mental Health Act and the associated regulations, you'll notice that the term qualified health professional is now used. In some cases where any of these three professions can complete the authority, they use the term qualified health professional. There are still situations where some of the authorities or responsibilities are limited to physicians and psychiatrists, and they'll use the term physicians there. Or they might be limited just to psychiatrists and they'll specify psychiatrist. So as you're going through the Act, you'll notice that there are some changes, mostly in relation to who can complete some of the forms. But there are also some changes in terms of notification requirements. So in the past, at discharge, a discharge summary was required to be sent to the person's family physician. That has now been updated and replaced with references to the person's physician or nurse practitioner who treats the person in their ordinary day-to-day healthcare needs for the purposes of meeting their health needs. So as we go through, we'll take a look at this table and try to keep this in mind that when we're looking at Form 1, for example, a Form 1 admission certificate can be completed by any of the three qualified health professionals. There's still a requirement in the admission process that one of those Form 1s must be completed by a physician, and one of the qualified health professionals must be a staff at the designated facility. Similarly with Form 2, a single individual Form 2 can be completed by a psychiatrist, a physician, or a nurse practitioner, but one of those examiners and issuers must be a psychiatrist in order for the set of renewal certificates to be valid. We mentioned the Form 2.1. This form can only be completed by a physician, so a physician or a psychiatrist. Form 3, which is the order to return a formal patient to a facility if they've left without approval, has not been impacted by Bill 17. Form 11, the certificate of incompetence to make treatment decisions, itself hasn't changed very much, but it's only able to be completed by physicians and psychiatrists. We switch gears a little bit now to look at some of the changes to the responsibilities of designated facilities. And we start with noting that there is now a definition of treatment that is included in the Mental Health Act. It's fairly vague. It talks about treatment as being defined as anything that is done for therapeutic, preventative, or other health-related purpose, including the implementation of a treatment plan. And there's now a requirement that the board of a designated facility shall ensure that a formal patient is provided with a written, individualized treatment plan within a month of their second admission certificate being issued. The treatment plan must include the type of treatment expected to be provided, the criteria on which a formal patient will be released under the authority of the Mental Health Act. So a person could still remain as a voluntary patient, but this criteria for release is just getting them to the point where they are no longer a formal patient under the Mental Health Act. And lastly, the criteria for that individual to earn a leave of absence. So day passes, privileges, and whatnot. Initially, we thought that the currently existing treatment templates would be easily adapted to include this. So some of the earlier presentations we did said there was not going to be a provincial standard treatment form for Mental Health Act patients, formal patients. That has since changed, and a provincial template is being developed, and we hope to have that available and communication about it being made hopefully in the next couple of weeks. So hopefully the treatment plan will not look different than treatment plans that are being used currently. They'll just have specific sections where these three criteria are explicitly met. There's also a new requirement in the Mental Health Act that admission and renewal certificates are reviewed for completeness prior to somebody being admitted as a formal patient. So prior to this, there was no formal process that was standardized. We do know that there were, at certain sites, there were formal and in some cases informal processes where there were these natural kind of checks happening. But because now it's a stated obligation in the Mental Health Act, Alberta Health Services is developing a provincially standardized process to review the certificates for admission and renewal prior to them being issued. And it would occur during, right after the second form would be issued typically. It would be most likely completed only at designated facilities for right now, but there's still some details of that process being worked out. There will be a provincially standardized form that is just about ready to go. And again, there will be more information and supporting resources made available for that process as soon as it gets finalized. This is related to a second requirement that's been added to the Mental Health Act, where Alberta Health Services has to provide an annual report to the Minister of Health on the completion, accuracy, and the use of forms to detain somebody under the Mental Health Act, as well as any other issues that the Minister of Health may request. Because this is an annual report, there are some additional factors that go a little bit above and beyond just assessing the completeness of these forms. So that process is still being developed, and again will be announced probably a little bit later than some of the other new processes, just because we have a little bit more time to finalize it.
Michael?
Yep.
Is it okay if I butt in for just a moment on the last slide, please?
Sure.
So one of the things that I think is really important for individuals to know is that this is a requirement that has already started. And since there isn't a form related to it already, it doesn't mean that this shouldn't be occurring already. And I think that that's some of the messaging I think is really important to get out to the designated facilities to really be keeping an eye on that information that Michael has just provided, where a document or system will be in place to capture that so that we can do annual reporting. It is important to, now really be watching, are these functions and are these processes occurring? And until that the forms are in place, how are you going to qualify that? Thank you.
That's an excellent point, Shannon. Thanks for cutting in with that. Yeah, that's important to keep in mind for all of these changes. They came into effect on September the 30th, so these are all active. And some of these we had a little bit of knowledge about, but the exact wording and sometimes the presence of these changes, it was a little bit of it went live, and then we had to make sure we have all these things figured out. So we are a little bit behind. So whatever you do to meet these requirements, again, we go back to documenting it until such time we have a standardized process. Yeah, good point, Shannon, that it still has to be completed and documented.
Michael, I'm just going to butt in for one more second.
Yep.
So the question that's just come into the Q&A is, who will be responsible for the annual reporting? That is an excellent question, and one that we're kind of figuring out. I don't know, Michael, do you feel that you have the time to kind of mention what the process is that? Yeah. Sure.
Yeah. So there's really two components to the reporting. So the first is, the process that we're looking at for kind of capturing the completedness of the forms will be something that likely will be completed by a unit clerk or a member of the nursing staff. And it'll be just looking at, is the information that's required on the form present and readable? And that will be completed and placed on the patient's file. But a copy will also be provided to a central person within each facility, and that'll be up to the facility probably to identify who's best suited to do that. And that person will be provided with something like in a standardized Excel spreadsheet where they can quickly enter any instances where there's incomplete information, and just capturing all the forms that have been reviewed. And that will be, I don't know if it's going to be monthly or quarterly, but on some regular basis, the process will have that electronic database, so to speak, being sent to a central person within Provincial Addictions and Mental Health. And so, like I said, that's for the completedness requirement. There are also some other requirements that have not been figured out exactly. And we'll have to kind of get the answers to some of the questions that I see that are popping up right now. I don't know that we have answers to all of these because some of the language is not specific enough, so it's open to interpretation. And so there might be some fine tuning that remains. But right now it looks like there'll be something relatively quick and not too onerous that happens during the process of somebody being admitted as a formal patient. And the collection of that data will kind of get rolled up in two steps. One step for the facility itself, and then the next step will roll it up for the province. And like I said, there are some additional elements for the report that we haven't exactly figured out how they're going to get collected yet, but those two things will be combined for that annual report. And any other questions on that, I'll let you put them in the Q&A and we can get to at the end perhaps. Going back now to look at the revised responsibilities of the facilities. We've always been required to notify a patient's guardian upon admission or renewal. And the patient has always had the ability to object to notification of their nearest relative. And nearest relative is the same definition that's always been present in the Mental Health Act. One of the changes is now that objection must be reasonable. So if the patient objects to their nearest relative being notified of their admission or renewal, then the treatment provider or the care provider, the care team, must decide whether or not that objection is reasonable. It brings us back to the same discussion we've already had about what reasonable means. So again, the same advice is document if you're going to determine that somebody's objection is not reasonable or reasonable, to document that rationale very clearly in the patient's record. If it ever goes to the patient advocate or to a review panel for discussion, kind of having that there is going to be really helpful. A second new addition is a requirement to provide a patient with a summary of the assessment of competence at the time of admission or renewal of admission certificates. This one, it doesn't have a requirement that it's written or not written, so there are a number of different ways that it can be accomplished right now, but there is a standardized provincial form that's being approved that would be quick and easy for a physician to fill out, and it would be attached to the notification documentation packages that are already being used. It's important to keep in mind that this summary is only required at the point of admission and renewal points. So one thing that we know happens frequently is that a person gets admitted, let's say on a Friday. It might be Monday, Tuesday, Wednesday before it's clear that this person does not have mental competence to make mental health treatment decisions. And so the Form 11 process has not changed. So in that scenario, on the Monday or Tuesday, the Form 11 process would start. But on the Friday, when that person was admitted, if it was the assessment that the person, we assume competence in all instances, unless there's evidence to the contrary. So the summary might say on admission on the Friday that the person is an adult who is competent to make their own mental health treatment decisions. And by Tuesday, that has changed. The Form 11 process would begin on the Tuesday, but the assessment of competence would not be updated until that person met the next renewal point. So 1 month later, another snapshot is taken of what that summary is at that time, and that's what's provided to the patient. And that's probably going to be something that causes some confusion, and we'll have to target through the education, but it's not expected that this assessment is being completed on a daily basis and provided to the patient repeatedly. It's when the patient is admitted as a formal patient and when they are renewed as a formal patient. And it's just that snapshot in time of what's true at that moment. So some of these things were already happening largely that you see on your screen now because of some of the supporting documents that have been created over the years in relation to notifying a patient of their rights and their notification of formal patient status. So we have to inform the individual of their right to legal counsel, the steps that they can take to obtain free legal services, their right to contact the mental health patient advocate, and their right to timely and free access to medical records for the purposes of appeal. I just see a question that's come back up for a second time, and maybe we'll make sure we get to that at the very end, Marissa. The revised responsibilities here, so there's a package of brochures that typically have been used in the past, as well as an AHS created form, the written statement of notification, certification, and patient's rights. These documents are being revised to make sure that they meet all of the criteria, and they're all in various stages of being completed. So that will help with the right to legal counsel, the steps to obtain free legal services. The current forms meet almost all of these. It would just take a little bit of extra care from the person who's doing the notification to make sure that these changes are being addressed. And one of the big ones to take note of is this right to contact the mental health patient advocate. In the past, there's been information provided to the patient on how to contact the patient, mental health patient advocate. So their contact number, reiterating that they can contact them at any point, that it's not a one-time only kind of a deal. The change now requires that staff actually ask the patient if the patient would like staff to contact the mental health patient advocate on their behalf. And if the patient indicates yes, then there are certain requirements. We must send over a request to the mental health patient advocate's office that contains some of copies of the admission or renewal certificates, as well as a summary of all the information that the patient was provided, specifying that they were provided, again, all this information about their rights, information about the patient advocate, about the mental health review panel, how to access these guaranteed rights under the Mental Health Act. The change related to the right to timely and free access to medical records specifies that any time a patient is having a mental health review panel or has appealed to the Court of Queen's Bench, they are to have free and timely access to their medical records. They do not need to ask for this. They are to be provided this. So once we know that they have been given a date, the expectation is that they are given the relevant medical records prior to the review panel hearing or the court date. There are processes that are being developed in order to meet this, but they have not been worked out. We know that there's some language in the current act that has caused some confusion, specifically in relation to maintaining compliance with the Health Information Act. Severing in particular has been a question. And at this point, it's our understanding that we are expected to be in compliance with the Health Information Act, unless it would interfere with the Mental Health Act requirement to provide that free, timely access to the medical records. One of the issues that we do not have an answer to is what is relevant and what is not relevant. It's not a concretely defined term, so there is some work underway to try to help put some limits on what would be relevant to a mental health review panel or to the Court of Queen's Bench, so that we're not having to provide, years and years and years of medical records, because not all of that's going to be relevant to the person's current situation. Another change relates to the Form 6, which is the Memorandum of Transfer. This is a form that's always caused a little bit of confusion. Form 6 has always been a form that's only required during the transfer of a formal patient, so somebody who has 2 admission or 2 renewal certificates completed, from one designated facility to another designated facility. It was never required when somebody was coming from a non-designated facility or if they're being transferred as a voluntary patient. This form is no longer required when an individual is being transferred between a designated facility to another designated facility of the same health authority. So between Alberta Health Services facilities, no Form 6 is required. Transfer between Covenant Health facilities, no Form 6 is required. But if somebody is being transferred from an Alberta Health Services designated facility to a Covenant Health designated facility, or vice versa, a Form 6 is still required. We know that this is going to cause some confusion, particularly in the Edmonton zone, and we're going to try to do our best with supportive education resources to eliminate some of those problems. But the thing to know is that if the person is being transferred from AHS to AHS or Covenant to Covenant designated facilities, no Form 6. If you're crossing between AHS and Covenant, the Form 6 is required to transfer a formal patient. Again, something that received a lot of attention in the lead up to September 30th and proclamation of Bill 17 was the introduction of secure locations. A secure location is a location that's been designated by ministerial order and named in the Mental Health Act regulations. At this time, there are no named secure locations. There's ongoing work between Alberta Health Services, Alberta Health, and other stakeholders to identify what's required at these sites and identifying the best places to start. So it'll likely be that there are a couple of places that will be named secure locations sometime in the future. But as of right now, there are no secure locations. It's also important to note that in the lead up to September 30th, there was some language in Bill 17 indicating that there were specific requirements for peace officers who conveyed somebody to a secure location and would obligate a a peace officer to repatriate that person back into the community if they were examined at the secure location and no Form 1 was issued. That section, it was 12.1, has not been proclaimed. So if tomorrow there was a secure location that was announced, that section 12.1 that talked about obligations for conveyance after examination at a secure location has not taken effect, and we don't know if it ever will. It hasn't, unlike the definition that we know is coming in March 31st, 2021, we don't know if the 12.1 authorities for peace officer section is ever going to be proclaimed. The purpose of secure locations is for somebody who has been apprehended by a peace officer under a Form 10 or a Form 8, so the police officer's information or a warrant from a judge, can be conveyed to a secure location for an examination by a qualified health professional. And the idea is to cut down on some of the more lengthier conveyances within the province. So that's some of the factors that are being considered in identifying where these secure locations might end up in the end. But we're not there just yet. Only the initial assessment, considering if a Form 1 is going to be issued, can take place. It's not a place for treatment. It's not a place for somebody to go and sober up. It's a place just for that first Form 1 assessment to happen, and then conveyance onto the designated facility if that Form 1 is issued. The Mental Health Act also now allows explicitly for the assessment and examination of an individual over video conference if they are at a secure location or a designated facility. This has always been part of the CTO regulations, allowing for video conference and remote examinations under certain circumstances. And this now explicitly allows that when the individual is at a designated facility or a secure location. If it's appropriate or not to do an assessment over video conference is up to the examining qualified health professional. They could decide that it's not a viable method to examine a specific individual and may request that person be conveyed and assessed in person, or have to wait for a person to show up at that site to do the examination. They also have the ability to request that a staff member at the designated facility or the secure location be present in the room with the individual during the examination. And there's some language in the Act that basically allows for communication between that staff member and the qualified health professional without getting written consent from the patient. There are some changes also in the Mental Health Act relevant to community treatment orders. So in relation to the criteria, there have been some changes to the harm criteria, specifically that it's been narrowed by the introduction of phrases that are the same as the criteria for admission or renewal. So again, we look at the phrasing of within a reasonable time likely to cause harm to others, and that the potential harm must be a direct result or related to the mental disorder. So that's just looking at consistency between admission criteria and CTO criteria when we're talking about the risk of harm and negative effects. The non-consent clause, the ability to issue a CTO without the individual's consent prior to September 30th required that there was a demonstrated risk to another person. With the amendments, it's now also possible to issue a CTO without consent of the individual if there is risk of negative harms to the individual or negative effects to the person. And again, it uses the same language as we see in the admission criteria, so the negative effects to the person, including substantial mental or physical deterioration or serious physical impairment, and still includes any harm to others. So a little bit of an expanding of the ability to issue CTOs without the individual's consent. As I mentioned earlier, there have been some changes to some of the review panel authorities. Those stem directly from the introduction of the ability for a formal patient to request a review panel to consider the issuance of a community treatment order. So essentially, if a person is a formal patient, in the past, they could request to have their admission or renewal certificates canceled. Now they have another option. Instead of outright canceling the certificates, they can request a CTO. The review panel has also been given the authority, If they are considering a request to cancel the admission or renewal certificates from a patient, they could come to the decision, instead of canceling those certificates outright, they could instead order that a CTO be issued. And in that case, the only thing we know about the process is that their decision would be communicated to the board of a designated facility, and then every other aspect of issuing the CTO would happen as a normal CTO. So taking the time to do the examinations, taking the time to arrange a proper treatment and care plan, and make sure that those resources are available in the community. So the language of the Mental Health Act does allow for that to happen. It's not a situation where the order comes in and you've got to make a CTO happen in 2 days. It provides, again, kind of language that says there's an amount of time that needs to be reasonable. It can't be delayed without good reason. And so the normal processes, for setting up a CTO might take days to weeks. It's a situation where it's taking a lot longer that might be looked at a little bit more critically. As I mentioned, the designated physician section has been repealed. CTOs can now be supervised by any of the 3 qualified health professionals effective September 30th. The time frame for doing examinations when you're renewing a CTO have been increased from 72 hours to 7 days. The time frame between examinations during the issuance of a CTO is still 72 hours. But once somebody has their CTO issued and they're up for renewal, there's a bit more flexibility in arranging those 2 examinations that are required before renewal. So this table again kind of shows in relation to the CTO forms that are used. So Form 19 and 20 can be completed by all qualified health professionals. There still is the caveat that one of those issuers, one of the examinations must be completed by a psychiatrist. Form 21, the amendment, can be completed by any of the qualified health professionals. The written statement, same thing, any of the qualified health professionals. The Form 22, when a CTO is being canceled, it can only be completed by a psychiatrist. When Form 22 is being completed because the CTO has expired, that can be completed by any of the 3 qualified health professionals. But the cancellation can only be done by a psychiatrist. An apprehension order can be completed by all of the qualified health professionals, and the examination on apprehension can be completed by any of the 3 professionals, but one of the examiners must be a psychiatrist. Some of these have already been covered, again, in relation to the new authorities to order that a CTO be issued, either as an alternative to canceling certificates outright or as direct requests from a formal patient. There has also been some increased authority for the mental health review panels to request a psychiatric assessment and examination. So in the past, that was limited to situations when a treatment order had been requested, and specifically looking at what's in the best interests of the patient. And with these amendments now, there is increased ability to have another psychiatric assessment to help aid them in their decision making. Previously, the mental health patient advocate could only initiate an investigation without the patient's consent into procedures of a facility. And now the mental health patient advocate can initiate an investigation into any matter relating to a formal patient. The Mental Health Patient Advocate may request in writing from the facility, board, regional health authority, or issuing qualified health professional any policy, directive, medical record, or other record relating to the patient subject to an investigation or to whom an investigation relates. And the documents that are requested must be provided to the patient advocate's office within a reasonable time. And again, this is a formalization of something that was already happening quite often in terms of cooperation in ensuring that a patient's rights are upheld. So some of the responsibilities that are laid out a little more clearly with these amendments, as I mentioned earlier, if the mental health patient advocate is contacted by a patient or by staff of the designated facility on the patient's behalf, they have to reach out and make contact with the patient. They will help make sure that the patient is provided information related to their rights, their ability to access the review panels, essentially circling back and making sure that all the rights and responsibilities that the Mental Health Act obligate the facilities to provide to a formal patient are being met, and if not, to rectify that and make sure that they are. So we have about 10 minutes left for questions. I'll just mention the list of resources that you're seeing on your screen right now. The Mental Health Act and all the associated regulations have been posted. They're all available on the Queen's printer. There are some background documents that are available on the health law section of Insight, including some of the communications that have gone out over the last number of months in relation to Bill 17 and then the subsequent proclamation of Bill 17. A number of the resources that people have typically used available on Insight as well as AHS's external website. Some have been pulled, replaced with a poster kind of saying temporarily unavailable. And we are working as hard and as quickly as we can to have those resources replaced. But until some of these internal processes are concluded, some of the resources just cannot be updated. So stay tuned. There are a lot of steps to get some of these things back up, but you'll notice that some of the resources have already been replaced. Some hopefully will be replaced in the coming weeks as well. Okay, I'm going to turn it over to Shannon now to just walk us through the questions that we've gotten during the presentation. And
hi, thank you. It was pretty action-packed back here, I tell you. So, Michael, I'll get your help with a couple of these question answer kind of things. But Marissa had asked, are we asking that the individuals save digital copies of the completed forms ever?
No, so I can answer that.
Okay.
That's okay. I was going to say no. There are some forms specifically related to the CTO that are completed. The process is completed over a number of days and up to weeks. And so being able to save a form that you're working on and complete it later can be helpful. For the admission certificates, probably not. So it's not a requirement. It's just the option that if you're filling out a form that you're not able to complete in that moment, as opposed to printing it and filling it out in hand later, you can have it emailed to your address, and it'll give you a link that lets you go back to that form where you left off and finish completing it. But the link itself will disappear after, I think it's 15 days.
Cool. Excellent. Thank you. Amanda is asked, which is a great question. And I think lots of people have been asking this type of question. If someone is formed using old admission certificate, is it mandatory to receive another admission certificate using the new form in order for it to be valid? I indicated that after September the 30th, no old forms are being utilized. And so if, for example, on September 30th or October the 1st, an old form was used, old form 1, and then a new form 1. Unfortunately, both forms must be of the newest version. So potentially, depending on the time and different things like that, an examination and the issuance of another form 1 would be required. Any comments on that one, Michael?
Nope, that's exactly what I would have said.
Christine was asking who will be responsible for the annual reporting, and I think that you addressed that kind of in the moment. And so, like I say, we are trying to get that together, and identify the processes, who's most appropriate for, ensuring that information is being collected and sent on. A member of our team will be doing the collection of the information annually, and our team will be sending up the annual report to the minister. Sylvie said, for these responsibilities, is it only once 2 admission certificates have been completed? And I'm thinking that, what time was that, 11:28? It might have been, Michael, when you were talking about, the rights piece.
Mm-hmm. Yeah, so there are some rights that are required under the Charter of Rights and Freedom anytime somebody's being detained. So, the person who's detaining the individual needs to tell them why, under what authority, and they have some rights there. but the responsibilities of the facility are limited to the situation where the individual is, that I was speaking of, is a formal patient. So 2 admission certificates or 2 renewal certificates. So the
Excellent.
answer, yes, covers that.
Oops, I'm sorry. Twyla asked, is the annual reporting for the designated centers, or is it required for all, but all sites? I think that's such a good question. And, we're trying to kind of get a handle on that right now. It's the responsibility of the designated facilities to ensure that information, but we are trying to capture how we may be able to include additional information. Sometimes we're hearing that the designated facilities, there's an individual coming under one Form 1, and that one Form 1 is not actually a valid, complete Form 1. So, what does that look like? It ends up that potentially 2 Form 1s would be issued within the time frame following arrival to the designated facility. Hopefully that cleared that up. Victoria, all old forms are now canceled and a new one must be completed, or must a new form only be completed when the old one is close to So I think Victoria was really just asking about like the existing forms that are in use that are now from prior to September the 30th. Those remain in existence, and as renewals are done or as issuances are completed, then that's when the new forms would be utilized. Christine, I think you've got such a great point here and perspective, and Michael, you may have things to say about this one. Is Christine is really kind of talking about how that oftentimes when the individual is brought to the designated facility, that they don't really consent to the nearest relative being notified. That now needs to be under reasonable grounds as to why that they would not be allowing for notification to their nearest relatives. Is that correct, Michael?
Yeah, so in the past, it was a straight up yes or no answer. Yeah. If they said no, we respected that. And there's some caveats if the nearest relative is also the substitute decision maker, that changes things a little bit. But in the current state, if they object, there's a second question that the notifying professional or the treatment team altogether must make a decision on, and is their objection based on reasonable grounds? If it is, then we would respect their decision and not notify. If it's not reasonable, then if you make that determination, then you have to go ahead with the notification.
Yes, a little bit tricky, and yes, there will be some growing pains, I think, over the next number of months to try and kind of get some of this addressed, but that's what we have now. And I think, Marissa, we were able to answer the digital copy of the Form 1. Victoria, I did get Michael to kind of answer right in the moment about the relevant medical records for the purpose of an appeal. So I think that we got that one. What else do we have? Oh, Form 6 stuff. I love Form 6. So Marissa, I'm not sure if you're from EMS, but Form 6 has been an issue for us for years and years and years, as long as I can remember with the Form 6, because oftentimes people have not understood the requirement for the use of the Form 6. The Form 6 is only ever and continues to be only used between designated facilities, not non-designated sites and rural sites, hospitals, urgent care centers, any of those things. So it, as Michael explained, it's from AHS to Covenant Health now, or Covenant Health to AHS, but it is not required between AHS designated facilities and Covenant Health designated facilities independently. But yes, there has always been a lot of confusion about the Form 6. It has never been a requirement for a non-designated facility to have. Oops, sorry, Michael, go ahead.
No, I was just going to say, I was reading ahead and we have 1 minute left. So,
okay, yeah, I see that. Sorry, I was trying to get to that. Okay.
Yeah, I was just going to say, so Alex's question, just touching back on the beginning, do the changes in definition to mental disorder and requirements for Form 1, what, if any, effect or changes does that have on the grounds for Form 10 by a peace officer? And Shannon answered the back that as of September 30th, police, RCMP, municipal forces have new languaging, and that's in relation to within a reasonable time, likely to cause harm to others or suffer negative effects, including substantial mental or physical deterioration or serious physical impairment as a result of or related to the mental disorder. So that's, again, mirroring the language that they use for the admission or renewal criteria. One other thing that has come into effect is that there's languaging that essentially we're not requiring law enforcement to be diagnostic magicians. And so there's languaging that states that it's safe for the law enforcement officer, peace officer, to assume that the mental disorder is not caused by one of those excluded congenital or brain injuries. So once the new definition comes in on March 31st, the languaging in the regulation kind of excludes police officers having to think too much about, is this due to a brain injury or anything else, unless there is direct evidence that says this is the direct result of. And so there might be some unique situations where that information is present on site. But there is language built in so that police are not having to, peace officers are not having to differentiate between brain injuries and other conditions. So I just wanted to add that piece to your answer, Shannon. Okay.
Then I was muting. I know we're over the time right now, and I know that Christine Adams still has some kind of questions. I think, unfortunately, we have to take that offline, and we'll try and respond to you, Christine, via email. But so much appreciate all the attendance and participation and great questions today. So thank you from my side.
Thanks, everyone. And we'll reach out with any of those questions that are unanswered. Thanks. I will just add that here's our email address. Any questions that haven't been asked can be emailed here. And there will be further education provided in the coming months that go into more details, like I mentioned at the beginning. Thanks, everyone.